It's now my honor to introduce to you our next speaker, Mr. Stephen Fung, who is a patent attorney and a partner of the International Patent and Trademark Attorney firm. Mr. Fung will talk about what are the secrets of a patent and trademark attorney. Tell me everything. Let's give him a warm welcome.
Well, thank you. A very good afternoon to all of you, to Professor Wagner, Professor Luke, distinguished guests, and ladies and gentlemen. It's a pleasure to be here. After Professor Luke's discussion and presentation on the various new laws that are being introduced in Hong Kong, it is indeed a very exciting time, particularly for those of you who are coming through the university and having an opportunity to explore whether a career in intellectual property is suitable for you. And hopefully today in this presentation I will give you a rough idea on what we do for a living, and perhaps for those of you who are interested, some strategies into potentially getting into this field as well. As a bit of a background and quick introduction, my name is Stephen Fung. I'm a partner of the international law firm Marks & Clark Patent and Trademark Attorneys. We're traditionally a UK-based firm but have been in Hong Kong since 1984. And I've been in Hong Kong since before 1984, but obviously I wasn't working as a patent attorney since 1984. It's a quick introduction. I'm a Hong Kong-born boy, and I grew up in Hong Kong, and I went overseas to study and subsequently qualified as a patent attorney and as a lawyer in Australia, and returned home here to Hong Kong to practice as a patent attorney. So with that in mind, I'd like to give a brief discussion on what our profession is like, and also some hints and pointers for those of you who are interested in joining this particular profession. So sometimes the patent and trademark attorney is referred to as a bit of a secret profession. Very few of us actually go out there and tell people what we do. And of course, I doubt very much I've met a child who said, I want to grow up to be a patent attorney. They simply don't exist. You can grow up in wanting to be a pilot, or you want to be a lawyer or a doctor or an engineer. But I've never seen anyone who said they want to be a patent or a trademark attorney. And I guess hopefully today we get an opportunity to tell everyone about our story as to what we do. And I'm certain that in Hong Kong there are so many television series, you'll never see a TV series on patent attorneys, because we live very, very boring lives, as it turns out. But I would disagree. So hopefully by the end of this presentation, I would have provoked some interest in you in knowing what we do, and perhaps some of you may even want to become an attorney yourself and follow in all the footsteps of programs that Professor Luke has set up and go ahead and qualify in Hong Kong. So what exactly is a patent and trademark attorney? Well, yes, as Professor Luke had said, we're not really lawyers in the traditional sense. Some of us are dual qualified. There are many patent attorneys who have gone through the program and acquired a law degree and actually did a qualification and are registered as lawyers. But to put simply, you would not want to call a patent attorney or a trademark attorney if you were ever arrested at 3 o'clock in the morning, because chances are he or she will not be able to help you. But they do specialize in intellectual property, and very often they specialize in things such as patents and trademarks, two very specific and important instruments of intellectual property. Many attorneys will do both patent and trademark attorney work. Some will just do patent work, some will just do trademark work. And of course, many attorneys are also dual qualified as lawyers, and they may even do some legal work on the side as well. It really will depend on the individual and the individual person, how they choose to run their practice. And of course, some attorneys will even be litigation specialists. They will go out to court and they'll be sitting at the bar table asking the judge to put down an order to enforce intellectual property rights to various different offending parties. So there are different types of people, but yes, there is a big difference between patent and trademark attorneys and lawyers. And why is there such a big difference, you're probably wondering? I mean, you're using the word attorney, you have some knowledge of the law. Why the difference? Well, the reality of it is when you're working with innovation, inventions and technology, you need to have that technical background. You could be drafting a patent specification or prosecuting a patent specification which relates to the latest pharmaceutical product, the latest drug that cures all diseases. You need to know how pharmaceutical products work. You need to know how medicines generally operate. You need to know all of these scientific knowledges. And therefore, in order for you to work well with your clients, you need to have some type of background. Either a pharmacist or an engineer or a chemical engineer. It all depends on what specialty that you do. In my case, I'm a computer engineer. I studied computer engineering, and so I focus largely in electronics and electrical engineering and computer sciences. If you give me a pharmaceutical patent, I would say I wouldn't know how to do this because I don't know how drugs work, for example. So everyone do specialize in different types of fields. And of course, a technical background is very important. Certain attorneys will also work as litigators, and there are different types of work. Some attorneys will specialize in drafting and the filing of and prosecution of patent applications or trademark applications, but they may not be involved in litigation. But there will be attorneys who are specialists in litigation. So some of them will have certain detailed analysis and detailed knowledge of litigation. So such as when the judge is going to go on holidays, whether we delay or we quickly try and wrap up these proceedings. These are all litigation strategies, and certain attorneys will be more of an expert in these areas, and in fact they may even be IP litigation experts. They know the judges, they know what they do. So there are some major differences between traditional patent attorneys and trademark attorneys and lawyers. Although if you're at a dinner party, it's probably easier to explain that you're just a lawyer, because then everyone sort of knows, oh, that's what you do. And they'll probably avoid talking to you for the rest of the day. But that is indeed the easy way out. So what do we do? You're probably thinking, what do you as a patent attorney do, and why would I want to embark on a career as a patent or a trademark attorney? Well, generally we help scientists or engineers protect their inventions. So imagine if you are a scientist or an engineer and you could be working here at the university or in a company or in your own time, and you've developed something great and fantastic, in which case you need that protected. So you would come and talk to a patent or a trademark attorney, and they would look at your scenario and they'll look at your invention, speak to you, understand what you do, and help you with preparing, drafting and filing a patent application to protect that invention. And obviously, part of that process is they need to talk to you, get an idea on what you're doing, and hopefully go forward with protecting your patents. Similarly with trademarks. Very often when you're starting a business, you'll have your own brands, your own logos, in which case you need to have those protected as well. And of course, there's a third type of attorneys in IP, and there's what we call IP litigators, the specialist IP lawyers who are very good at enforcing intellectual property. They know what to do at a court level, they know which barristers to engage, they know what type of submissions need to be made. They're expert strategists. They know how to pick a fight and win it. So there are three different types of roles that we call IP attorneys, and in fact there are others, no doubt, but these are the main ones. And perhaps one of these may be suitable for you depending on your background and your knowledge and whether you're willing to go and undertake the education processes. We often get asked, is our job difficult? Is being a patent and trademark attorney difficult? And the answer is yes, it is. It's very difficult because the laws that are involved in intellectual property is very complex. More importantly, it's also very international in nature. Chances are, when you are applying for a patent or a trademark, you don't just want a patent or a trademark in Hong Kong. You want it in many places around the world. You might want it in China. You might want it in the United States, or you might want it in Europe, or any other countries where you'll be doing business. So you need to know the laws generally around the entire world. And that's a lot of laws you need to understand. Fortunately, there are similarities between each of the different countries, but nevertheless, you do need to have a good overview of everything. Also, very often, inventions do change from time to time. If inventions do change from time to time, it means the work that you do and the advice that you give will also change from time to time. And as part of your duties is you must know the law so well that you can change your advice from time to time to suit the needs of the inventor or the person who's applying for the patent or trademark. So naturally, you will need to merge the skills of being an engineer or a scientist with those of being a lawyer. And that can be quite a tough ask. But often, is our job interesting? Well, I would say to you, absolutely. And the reason for that is because you're working with the forefront of technology. When you are working as a patent or a trademark attorney, you are doing new things every day. And that's a great thing, because the last thing you want is a repetitive job. If you are doing this, if you are working in innovations, you get to meet different people, different inventors. And even if they're the same inventors, they may have a different invention. And when you work with people who are building their own inventions, it's usually their life's work, or very often a very important part of their work. So they're very enthusiastic about it. And part of the fantastic aspect of our job is we get to meet different types of people every day and look at the new innovations that are created. It's almost like going to an exhibition for the latest smartphones, the latest computers, the latest car, the latest fashion. You get a chance to do that in your everyday job. So it's never really boring, because everything is different and every day is a challenge. Now that I've given you an idea on what we do, you're probably asking, what are the different career paths, and is this something that I really want to do? I mean, after all, it is a big step for me, probably as a scientist or an engineer, to want to do something so different. Well, in fact, there are a lot of jobs that are available out there. One of which is, of course, if you join a private firm, such as the firm that I'm in or any other firm that's out there, where we provide a service for a fee. That's a very common way of starting in this business, is you find a private firm and you start to go in there and get a job and train through their program. That's one way of seeking a career path in the IP business. There are also in-house positions. So companies that have very large IP portfolios will need somebody to manage their IP. You know, to chase up on deadlines, to manage whether the engineers is capturing their inventions properly, whether the lawyers that you're using has given you the right advice. So there are plenty of these in-house positions as well, and many of them do exist in Hong Kong, as well as in countries like Singapore as well, in this particular region. In-house positions have been very common overseas in America or in Europe, but they're also starting to appear here in Hong Kong as the IP as the amount of IP grows out of this region. The third type of role that you often get is with government bodies, such as the Intellectual Property Department. Now, there are plenty of experts who work in intellectual property departments and other government bodies here in Hong Kong. You know, patent administrators and patent examiners, people who need to look at those patents and trademarks that are filed and see whether they comply with legal requirements. In those particular positions, they also need experts, engineers and scientists in that particular area. And that's again something you can explore, because you are also doing similar type of things as what you do as a patent and trademark attorney, except you're working on behalf of the government. With the originating patent grant program, the Intellectual Property Department will need to expand the size of their patent examination service, and no doubt that will create new opportunities for graduates, particularly in engineering and science, to go into these particular roles. The famous patent examiner is Albert Einstein. He was a patent examiner with the European Patent Office many, many years ago. It's been said because that job gave him so much free time that he managed to come up with the theory of relativity whilst he was working there. Who knows what you'll come up with if you end up as a patent examiner as well. I have no doubt that you'll probably have a lot of coffee breaks also. But that will depend on the new roles that are about to appear, and of course the opportunities that will be made available to you in a very short future. And of course, finally, there are also organizations like the university here and other research bodies that have a lot of intellectual property, that creates a lot of intellectual property as part of their everyday work. And in these positions, they also need to hire many intellectual property experts to manage their IP. So again, that's another opportunity for those of you who want to pursue a career in intellectual property to follow through in obtaining a job or a position. Now, we often ask, is our career rewarding? And I certainly think it is, but obviously it does depend on what you regard to be rewarding, of course. Now, there are some benefits to our career, as I say, compared to anything else that's out there. At the moment, we're experiencing a lot of growth. Intellectual property is now a very, very major component of our economy, and we're also seeing major amount of growth in innovation, both here in Hong Kong and in this entire region. And these are all part of the government initiatives and also the changing nature of our youngsters who are going out there and saying, well, I'm actually willing to sit down and think of a new innovation and I want to capture it and then see where we go with it. So there's a lot of innovation that's being created in our region. So in other words, there's a lot of work that needs to be done in order to protect this intellectual property. So if you were to join the profession, there's a good chance you'll find a job, and you'll find a job that will take you to places. The other thing that's very important in our business is experience makes you a better patent attorney or a trademark attorney. What I mean by that is often as an engineer or as a scientist, you may fall into a slight problem of focusing in one particular type of technology. And maybe after 10 or 15 years, that technology sort of drifts away. And you find yourself into a position of where you need to retrain. But fortunately, as a patent or a trademark attorney, because you're constantly learning and being exposed to new things, there isn't really any major need, apart from the annual sort of attendance of seminars and retraining of new updates in law. You're constantly getting updates when it comes to understanding the technical background of your work. So your experience accumulates, and it makes you more senior, and it also makes you more valuable as an attorney in the long term, which is fantastic because it minimizes the necessity to retrain in the technical field. Yes, you have to obviously understand the new laws that are coming through, and laws are a constantly changing thing, but at least you're being exposed to new technologies all the time. Of course, the last 2 points, I don't want to make too much of a point of it. It can be financially rewarding in the sense that being a patent attorney is comparable to, say, being a solicitor in terms of pay and in terms of the work environment that you will be working in. I have found that most patent attorneys I've spoken to, the working hours are generally a little bit less than lawyers. It's more comparable to, say, with engineers as well. So you're getting the best of both worlds. You're getting an opportunity to work in a legal environment, but you can probably go home by 7 o'clock instead of 11:30. So there are certainly some benefits to working in this particular business. Hopefully by now, I've got some of your interests in desiring to take on a position as an IP attorney. So you're probably wondering, what are some of the qualities of a good patent attorney, and how do I go about applying for a job in this particular area? Well, the reality of it is you do need to have very good communication skills. Part of the reasons is because you're meeting new people all the time. You need to sit with them and you need to understand what they've done in order for you to capture whatever they've got. And sometimes you have to deliver good news and bad news. So communication skills make a huge difference. The other aspect, of course, is part of your job is to capture a very technical innovation and putting it into a written form, a legal document called a patent specification. Naturally, you need to be very good with languages. Whether it's Chinese or English, obviously depends on your region. It could be another language if you're practicing outside of Hong Kong. You need to be very good with languages and your language abilities, because most of your everyday work will be reading and writing. That's what it's all about. So that's an important component of this work. Now, you also have to have a good understanding of the technology you're working with. And it doesn't really matter what it is. It depends on the demands, obviously, at the time. If you're an engineer, that's great. You are familiar with a particular technology field. If you're a biologist, if you're a biotech person or a pharmacist, again, you have to have good understanding of that technology, and that will help you in your job quite well. The other last 2 points is you do need to solve a lot of problems. So you need to think, and you need to think every single day in trying to work around a particular problem that may arise. As I said, the interesting thing about our profession is every single invention is different. In other words, every single problem you get will be different at some stage. There will be some repeats occasionally, but chances are you're going to need to apply a new train of thought. And that means you're going to have to be solving problems on a day-to-day basis. And finally, one of the things is patience and willingness to work hard. Being a patent attorney means many years of training. It's, as I say, it is rewarding, but you do need to sit there and learn this again and again, and hopefully get someone who's going to teach you how to do things right. And that's a very important part of this profession. Certainly, if you want to embark on a career in this area, you will need to sit down and have some patience in learning things. It can take a number of years before you're an expert at being a patent attorney. So how do you become a patent attorney? I believe Professor Luke has already touched on some of the qualification programs that's being introduced. Now, of course, the qualifications in science or engineering seems to be quite mandatory across the world. There are some jurisdictions where this is not necessary, New Zealand being one of them. I believe the laws are changing there yet again. But generally, you will need to have some type of scientific background or engineering background. After all, you are working with the technology. So you do need to have that as a background. Now, studying law is optional. Now, when I mean studying law is optional, I mean a law degree is currently optional. That is, being a lawyer. You do need to study law when you are working as a patent attorney. You cannot avoid studying law. So it's not optional in that sense, but doing a law degree at the moment is optional. The way it works is if you've met the minimum requirements, you then go and join a firm or join an in-house position and start out as a technical assistant, or what we call patent engineers or trainee patent attorneys. In these positions, you will be asked to basically assist a senior patent attorney with their work, and in that process, you learn the laws that are required. You also learn to draft patents. You also learn to do searches. You also learn to do various aspects relating to intellectual property. And you'll also be part of the team that will be solving problems as well. So during that period, you will be given an opportunity, in most cases, to study a patent attorney qualification program. And what you will end up doing is you'll sit a series of examinations. There will be a series of barriers that you need to cross. And that could take a number of years before you're successful. And after that, you then be registered as a patent attorney, either in Hong Kong, China, UK, Australia, US, wherever you choose to practice. You don't always have to practice in Hong Kong if you don't want to. One of the beauties of our beautiful aspects of our industry is your skills are generally quite portable, despite the fact that the laws do change from country to country. You can take your skills and work overseas. You may need to meet some new requirements. For example, if you want to go to Singapore and work, you may need to sit the Singapore patent agent exam eventually, but you know, the work is pretty much the same. The clients are the same. The innovation the innovation process will be very similar. Now, for trademark attorneys, which I didn't spend too much time talking about earlier, most trademark attorneys will go into this profession as lawyers already, Hong Kong-based lawyers, and that is the case around the world. A lot of lawyers will start out as being an IP specialist or an IP lawyer, and they may start doing trademarks. And all of a sudden, before you know it, they're called trademark lawyers, and they practice in filing trademarks. There are some exceptions to the rule. In recent times, there have been a number of law graduates, people with LLB degrees, but haven't really taken on a PCOL program and has not qualified as a solicitor, but have gone ahead and did a trademark attorney qualification program, such as the one that's available in the UK. And as a result of that, they can be a registered trademark attorney in the UK, and allowing them to practice as a trademark attorney. So that's also a career path for those of you who have some legal study background but haven't yet taken out a PCOL or does not intend to take a PCOL. So we do see a number of paralegals who want to progress with their careers who have taken on this particular strategy as well in moving forward, instead of waiting to sit out the PCOL. So there's another option that's available to you. Now, finally, it's difficult to get a job into an IP role. It is hard relative to, say, getting a job as an engineer or getting a job as a dentist or a doctor, because if you go to a jobs website and you search the term engineer, you'll see plenty of engineering positions, no doubt, hundreds maybe. I have to admit, our profession is still fairly small at the moment. It is growing and there is a demand, but if you do go to a jobs website and you search with the words patent attorney or patent engineer, you may get 1 or 2 hits every so often, 2 to 3 months. So the opportunities are not very common, but they are increasing, and at the same time, not that many people apply for these jobs. So don't feel terrible about it just yet. Now, of course, when you do go for these roles, try and get a job that suits you and try and get into a good firm. Now, there is no such thing as a good firm in the sense that you can name the firm or name the attorney. It depends on you as an individual. It depends on your skill set and whether you feel that the work that you'll be given as an attorney will actually help you progress your career. If you're, for example, one of the attorneys who love to litigate, you like a fight, you may want to choose a firm that's constantly doing a lot of litigation. that's perfectly fine. If you're an attorney who likes to work with nanotechnology, for example, you may want to work with an attorney who specializes in nanotechnology and nothing else. That's also possible. So it depends on you as an individual. But hopefully, when you are working in that position, you will get good mentoring. You will be mentored and taught lots of skills that you will take away for life. And it can take a few years, of course. Going through the qualification process and learning the art is something you need to do. You have to invest a few years into this. One of the things that you should show is a genuine interest in joining an IP firm. There's nothing worse than going into an interview and not knowing what an IP attorney does. I've seen that in the last 3 years. We've recruited 6 local Hong Kong trainees who will go through the qualification programs with us, and we've been training them, and during that interview process we saw many candidates. Many of them simply wanted the job. They applied for a job that didn't even know what we do. I don't know why they waste their time, because we would never take anyone on who doesn't show a genuine long-term interest in working in IP. As I said, it's something that takes a long time to acquire, so one of the things that your interviewers will do, if you're interested in getting a role, is to see your genuine interest and your willingness to commit yourself. And of course, the last point is be on the lookout for opportunities. If you happen to meet a patent attorney or you happen to work with one as part of your research, keep the contact, give them a call. Don't be shy. Give them a call and say, look, I'm so-and-so and I specialize in this and I'm interested in becoming a patent attorney. Maybe not today, but in the future. Do you think you can give me some advice? And build up that connection, because by doing that, you're showing a genuine long-term interest in working in this field. And hopefully, the attorney that you speak to will say, well, I know so-and-so, and he or she always calls me up every six months, and he says, oh, okay, he seems really keen. Maybe we'll give this person a go. And that's a great way of getting into a firm. So if you are genuinely interested, that's something to also consider, is to keep an eye out for the opportunities that come your way. And of course, the last thing I'll leave with you is, as a patent attorney, many of us come into this profession by accident in some way or another. Some of us do choose to be a patent attorney, often because we've been coached or we've had the privilege of meeting one. But in most cases, it's a lot of luck and a lot of perseverance. It could take a number of years before you get that role. But if this is what you want to do, and you want to be rewarded with a successful career, then it's, in my opinion, a small price to pay, and certainly worthwhile. So that is the end of my presentation. It's been a privilege to give you that explanation. I'm sure that all of you will have some knowledge of what we do as patent attorneys. But of course, if you have any questions, feel free to ask those questions. I believe we'll probably take questions at the end of the seminar. Stick around and I'm happy to answer any questions as well. So thank you for attending.